Hello friends. Today we are going to discuss about doctors in training, illegal liability. I'll be discussing about important case laws in this video. I am Dr. Suresh Badadmat, Professor of Psychiatry, working at National Institute of Mental Health and Neurosciences, Bangalore. In this video, I'll be discussing about the legal liability with regards to doctors who are undergoing training. How the medical negligence committed by the doctors in training who will be held responsible, what is vicarious liability, and I'll be discussing about the Supreme Court decision with regard to doctors in training. Here in this video, the main focus will be, can a doctor in training be sued for his medical negligence? How does the vicarious liability play a role specifically with regards to doctor in training? That means if a doctor who is doing internship or a postgraduate student, if there is a medical negligence, will they be held responsible? Or the supervisor or the hospital, if it is a government medical college, will the government will be held responsible? That will be answered in this video. Let's look at medical negligence. To establish medical negligence in the court of law, the four important ingredients need to be proved. The first one is duty of care. The second one is there is a breach in that duty of care, that is, failing to provide a reasonable degree of care or a standard of care. Because of this breach, there is a damage, and the damage is foreseeable, that is, causation is linked to the breach of duty. All these four ingredients need to be proved by the patient or the patient's family members in the court of law. The medical professional is expected to bring a reasonable degree of skill and knowledge and must exercise a reasonable degree of care. The Supreme Court, in its various ruling, has clearly stated that the doctor needs to bring a reasonable degree of knowledge, skill, and care. It does not expect very high standard of care or the lowest standard of care. It is the reasonable degree what is expected from the doctor. But this medical negligence can be considered if the doctor did not possess the required knowledge or the skills or the degree. Further, if he had this knowledge, skill, and the degree, but he did not exercise the reasonable degree of competence, in these two important criteria, the medical negligence will be determined. Now the question is, if the postgraduate student or the intern, invariably they do not have the requisite degree or the post-graduation, how do we assess the reasonable degree of care in the trainee, that is, doctors in training? What will be the measure of standard of care? This issue has been haunted in many court laws across the world, especially in United States of America. Now let's discuss how to fix the liability with regard to doctors in training, that is, postgraduate students or maybe internship. Invariably, the medical negligence can be criminal negligence, can be civil negligence, and disciplinary action. With regard to medical negligence committed by a postgraduate or maybe an intern, invariably the criminal negligence directly fixes the liability on the student. That means the student should know what he should not do. And if he is doing certain procedures which is beyond his competence and skill, he needs to be under the supervision of the supervisor. That means vicarious liability usually is not fixed in criminal negligence. The person who commits the crime, that is medical negligence, that is criminal negligence, will be held responsible. Moving to the disciplinary action through the professional medical council. Here, invariably the postgraduate students are registered, they have a degree. So, the disciplinary action can be initiated with regard to medical negligence. Suppose if the doctor is an intern doing clericalship or housemanship, he is not registered. What will happen? Will the state medical council take the case? Will they stall his registration? Such case has not come to my notice through my literature review. Invariably, postgraduate students who are already registered can be brought under the rubric of state medical council, and a disciplinary proceedings can be initiated if there is a medical negligence case. In civil medical negligence, the vicarious liability will be coming into play. Now let's discuss about civil medical negligence. It is a common sense that when a patient goes to a hospital or a medical college or a corporate hospital, he goes with an account that the reputation of the hospital or the supervising doctor will be taking care of him. That means he believes the hospital is hiring a qualified or a person who is able to provide a reasonable degree of care in that hospital. That means it is the responsibility of the medical college or the hospital to provide the qualified doctors. If the hospital or the medical college fails to discharge this duty and leaves only the postgraduate students to provide care, and it does not have adequate number of supervisors, then the medical college or the hospital will be held responsible through vicarious liability if there are any medical negligence case occurs because of the postgraduate students. Now let's understand vicarious liability. Vicarious liability has two important maxima. The first one is Q facet per alium facet per se. Second one is respondeat superior. Q facet per alium facet per se means that whenever a person gets something done by another person, then the person is viewed to be doing such act by himself. For example, if you have a driver and he is driving your car, by chance, if there is an accident, then the owner of the car, that is you, will be held responsible through vicarious liability. That is Q facet per alium facet per se. The second one is respondeat superior. That means let the master answer. This is a legal principle that holds an employer liable for the negligence of its employees in certain circumstances. It means that the superior should be held responsible for the act done by his subordinate. Example, in a medical college or hospital, the case of a senior specialist and he is supposed to do the operation. Instead of that, the senior specialist or the specialist delegates this responsibility to a doctor in training or a student to perform the task. If there is any untoward incident or a medical negligence, the superior will be held responsible under civil medical negligence. Please remember, not under the criminal medical negligence. It is well established that a hospital is vicariously liable for the act of negligence committed by the doctors engaged or the employees or empaneled to provide medical care. That means the hospital cannot say, I have got this doctor on part-time basis, on case-to-case basis, or he comes and brings his own cases. If the hospital is providing the space for the doctors, they will be held responsible under the vicarious liability. They cannot give any excuse by telling that he is not a full time employee, he brings his own cases. Such kind of excuses will not be allowed in the court of law. Now let's discuss about an important apex court decision done by the Supreme Court of India in Douglas Lewis versus Manipal Hospital 2024. In this case, Mr. Douglas on 31st October 2003 underwent a major surgery on the left lung. That means left pulmonary area was surgically removed. This surgery involved removal of the cancerous tumor and removal of lymph nodes around the left recurrent laryngeal nerve. Post-operatively, Mr. Douglas developed hoarseness of voice. However, the doctor assured him that over a period of time and with nebulization and physiotherapy, his voice will be all right. Unfortunately, Mr. Douglas, the voice did not improve. Hence, Mr. Douglas took a second opinion and again he took two doctors' opinion. Experts opined that there was subluxation of left arytenoid process due to wrong intubation of a double lumen during the anesthesia. They also opined that it was an account of trauma occurred during the anesthesia. And during the surgery, the HOD of anesthesia was supposed to do the intubation. But unfortunately, he delegated this job to a trainee. This was a trainee who has done his MD anesthesia and he was undergoing training in cardiac anesthesia department. That means the person, although he had MD anesthesia, but still he was undergoing the training in cardiac anesthesia, but the HOD was not available at that time. Looking at this observation, District Consumer Forum said that since the HOD was not available during the surgery and it was delegated to a trainee who was qualified, and it also noted that Mr. Douglas was working as a area sales manager. For him, the voice was very important for his employment, and because of his hoarseness of voice, he was deprived of promotion till 2015. That means approximately 12 years because of his hoarseness of voice. Unfortunately, in 2015, he's come to the cancer. But however, the fight in the court of law continued. Please imagine, this case was in 2003 and the verdict came in 2024. Apex Court, in its decision on 6th February 2024, said that here the vicarious liability is considered a compensation of 10 lakh rupees with regard to hoarseness of voice, that is, subluxation of arytenoid processes because of the trauma for using the wrong intubation method by double lumen was considered. And further, they also said 10% interest should be paid to the family members. My dear friends, you have to appreciate here. The court focused only on the hoarseness of voice. Although the patient died because of the course of his cancerous illness, but the trauma which he continued because of the hoarseness of voice and he was unable to do employment. Hence, 10 lakh rupees as a compensation with 10% per annum interest was given. And it also said that hospital has to pay for the same. That means invariably, even the trainee is performing and the supervisor was missing. Hence, the hospital was held responsible. Now, let's understand why this contract of services and contract for services to be discussed here. Here, in such cases where The contract of services is there. That means hospital may refuse the trainee to not come under the employee. That means contract of services. Or he is not hired as a contract for services like a broker, or else case per case like locum. Neither they come under contract of service or contract for service. They may refuse to give compensation, and they make the trainee responsible for the untoward incident. However, the hospital should remember they are responsible for hiring the supervisor, monitoring them, and also making sure the trainee does undergo training under the supervision. If you look at the contract of service, that means it is an employer employee relationship exists. That means the employer, that is the hospital, has a complete control over its doctors and other staff. With regard to contract for services, it is a relationship akin to agency or maybe a locum or maybe a broker. For example, in certain cases, they may not have anesthetist. Anesthetist may be called to do to give anesthesia in certain one or two cases only. It may be a locum, that is contract for services. In contract of service, since it is employer and employee relationship, they have more control, the process of engaging, the time duration of work, what kind of cases will be done there, how many cases will be done, working hours will be decided. Hence, the hospital becomes complete liability under contract of services. Whereas contract for services, the control is limited based on specific contract only. Here the engagement is limited to specific work only, and the employer may say, I have only limited contract here. But however, although doctors in training, that is postgraduates, do not come under the contract of service or contract for service, invariably they are undergoing training under a supervisor who is under contract of service. Hence, the vicarious liability plays a role. In this regard, National Consumer Forum also has given an important landmark decision, and in that decision, it has observed that a hospital cannot escape its liability by merely saying that it cannot suo motu perform any operation or amputation, that it is provided only through infrastructural facilities, nursing services, support staff, technical technicians, equipments, medicine, and places. That means hospital cannot say just I am providing such services. And the doctors are professionals, they are doing their duty. The hospital is not only responsible for the staff it provides, but also for the independent contractors such as anesthetists, surgeons, doctors, or maybe the supporting staff who may be on contract. All of their medical negligence cases, the hospital has to take responsibility. In this regard, there was an important publication published in JAMA by Kachilia and Sturd in 2004. The title of the study was Professional Liability Issues in Graduate Medical Education. In this, the author concluded that the doctors in training are generally held to the same standard of care as a supervising physician in their respective specialty. That means the PG will be assessed based upon the supervisor's standard of care. This principle encourages the physician or the doctor in training to seek supervision from the supervisor. If this standard is not brought, the PGs will act independent physician and they will not seek any supervisor's support, and many a time the supervisors may become a ghost faculty. They may not do their job adequately. Hence, in this article, they are very clear. The postgraduates, the standard of care will be as equivalent to the supervising physician. And the supervisors face two important malpractice exposure, not only for the care they provide directly to the patient, but also to the care provided by the students under their supervision. Hence, my dear friends, supervisors have a huge responsibility. Along with, the hospital also makes sure that they don't have ghost supervisors or ghost faculty, which is well known in India. Many of our own medical colleagues sell their postgraduate degree for a meager amount of 10,000 or 5,000 rupees. And these ghost faculty will go once a year or a once in 6 months to collect their salary and sign the attendance. This is unfortunate. Think about the postgraduate students who learn without these supervisors. In this regard, there are many unanswered questions. What constitutes adequate supervision is unsettled. What should be done with these ghost faculties? What should be done for these supervisors who come daily in the morning and they apply attendance and they go for private practice? The complete medical college is in the hands of postgraduate students. What should be done? What should be the adequate working of hours of these PGs? Many a time these PGs are overworked and completely they are drained of their energy and mental fatigue sets in. Invariably, medical negligence occurs. Hence, we do not know what should be the workload, what is the safe working environment for the PGs, what are those circumstances which the PG should be held negligent, what is the elective surgery and emergency procedures, how the PG trainee should do, what is the role of the supervisors and senior residents is not been clear, and these are unsettled, and hence on case by case we need to discuss. So what are the remedies? The rationale here for insisting for a relatively high standard of care equivalent to the supervisor is that means the policy consideration and NMC regulation is very clear. Supervisor and trainee ratio has to be maintained. That means the medical colleges has a responsibility to make sure the supervisors supervise these PGs. And hence the supervisor are responsible for not only providing care to the patient directly but also through the postgraduate students. Hence, medical council may mandate that medical colleges providing doctors in training should have professional liability insurance. So if there is untoward incident occurs, the patient can directly sue the doctor and there is a liability insurance, that is indemnity insurance is there, and the standard of care is equivalent to the standard of the supervising physician. That is very clear internationally, and invariably in the recent judgment it appears the Supreme Court has taken a leaf out of from the international studies. However, this standard of care is not static. It is based on case by case basis, whether it is an elective surgery or is it an emergency case, whether the supervisor was available, whether the medical college had adequate number of supervisors, whether the patient came late, whether the patient refused consent. There are too many factors are involved, such as it may be the circumstances, whether the blood bank was working properly, whether the instruments were working properly, and whether the medicines are available. On this basis, the case will be decided. Hence, there is no single formula or straitjacket formula to assess medical negligence in postgraduate students or in the internship. To conclude, the UGs, interns, and PGs are meant to be trained under the supervision. Hence, the medical colleges should focus on training, not generating revenue out of patients. Accordingly, it is advisable to ensure arrangement of precise upfront what is the role of the PGs and the supervisors, and the document of SOPs should be made available to the PGs, and they are not going to do any independent cases, And if they are going to do, it has to be under the supervision. And the supervisors should be made responsible for the PG's act. Hence, proper supervision is mandated under NMC Act and its regulation. Thank you very much for giving your valuable time. Stay safe.